I was standing at my kitchen window drinking morning coffee when I saw the construction crew breaking ground on what appeared to be my back field, and my stomach dropped faster than a lead balloon. My name is Xavier Brennan, and I'd owned this 12-acre property outside Columbus, Ohio for nearly 8 years. The house sat on about 2 acres, with the remaining 10 acres of open field stretching behind it. I'd always loved that field. It was why I bought the property in the first place. Wide open space, perfect for eventually building a workshop or maybe getting some horses. The possibilities felt endless. But now there were orange construction markers everywhere, a bulldozer, and about 6 workers in hard hats milling around what looked like playground equipment still wrapped in plastic. I didn't even bother putting on shoes. I ran out my back door in my socks, crossing the dewy grass toward the construction site. The field sloped gently downward from my house, and I could see everything clearly. This wasn't some mistake where they'd gotten the wrong address. This was deliberate, planned construction. "Hey!" I shouted, waving my arms. "Hey, what the hell is going on here?" A middle-aged guy in a yellow hard hat turned around, clipboard in hand. He looked annoyed at the interruption. "Sir, you need to stay back. This is a construction zone." "This is my property," I said, breathing hard from the sprint. "You're on my land." The guy's expression shifted from annoyance to confusion. He glanced down at his clipboard, then back at me. "This is the Meadowbrook Hills Community Playground site. We have permits." "I don't care what permits you have. This is my field. I own this land." Another worker, younger, came over. "Boss, we should probably sort this out." The first guy, whose name tag read Jim, pulled out his phone. "I'm calling the project manager. Just hang tight." I stood there in my wet socks, arms crossed, watching as more workers stopped what they were doing to stare at the unfolding drama. My heart was pounding. How could this happen? How could anyone think they had the right to just build something on someone else's property? 10 minutes later, a silver Lexus pulled up to the edge of the field, and out stepped exactly the kind of person I'd been dreading. She was probably in her mid-50s, with that aggressive blonde haircut that screamed, "I want to speak to the manager," wearing white capris and a floral blouse despite the early October chill. She had a leather folder tucked under her arm and wore the expression of someone who was already convinced she was right about everything. "I'm Patricia Donovan," she announced, not offering her hand. "President of the Meadowbrook Hills Homeowners Association, and you are Xavier Brennan, the owner of the property you're currently trespassing on." Patricia's lips pursed into a tight line. "Mr. Brennan, I don't appreciate the accusatory tone. We have all the proper documentation for this playground. It was approved by the HOA board 6 months ago. We have county permits, and construction was scheduled to begin today. Everything is completely legal. Except you're building it on land you don't own." She actually laughed. It was a sharp, dismissive sound. "The playground is being built on HOA common area. This field has always been part of the Meadowbrook Hills community space." "No, it hasn't," I said, forcing myself to stay calm. "I bought this entire property in 2017, all 12 acres, the house and everything behind it." Patricia opened her leather folder with a flourish. "Mr. Brennan, I have here the original community plat maps from when Meadowbrook Hills was developed in 2001. This field is clearly marked as common area space, reserved for community use. The fact that it borders your property doesn't make it yours." She showed me a faded map with various lots marked out. I could see the general outline of the neighborhood, but the map was old and not particularly detailed. "I have a deed," I said. "A legal deed that describes my property boundaries. This field is included." "Then your deed is wrong," Patricia said with absolute certainty. Or you're misreading it. This field has been part of our community since its inception. Just because no one's used it until now doesn't change the facts. I couldn't believe what I was hearing. So you're just going to keep building. The playground will be completed as scheduled. We've already spent $43,000 on equipment and labor. Our community children deserve a safe place to play. Build it somewhere else. Build it on land you actually own. Patricia snapped her folder shut. We are building on land we own. I suggest you consult with your real estate attorney and review your property documents more carefully. Now, if you'll excuse me, I need to ensure this construction stays on schedule. We've already had enough delays. She turned on her heel and walked back to her Lexus, leaving me standing there in disbelief. Jim, the foreman, shrugged apologetically. Look, man, I just work here. The HOA hired us. If you have a property dispute, that's between you and them. But unless you have some kind of court order, we're going to keep working. I walked back to my house, my mind racing. This couldn't be happening. I pulled out my filing cabinet and found my closing documents from 2017. The deed was there, along with all the property descriptions. The survey. Everything. I spread the documents across my kitchen table and read through them carefully. The property was described using meets and bounds, those technical legal descriptions full of angles and distances. It started at one point and worked its way around the perimeter. I wasn't a surveyor, but it seemed pretty clear that my property extended well beyond just the house lot. The survey map was more helpful. It showed the house and a clearly marked boundary line that encompassed the entire 12 acres, including the field where they were building. I took photos of everything with my phone, then called the title company that had handled my closing. After being transferred 3 times, I finally got someone who could pull up my file. Yes, Mr. Brennan, your property is 12 acres, the woman confirmed. The survey was completed in 2017, just before your purchase. Is there a problem? Someone is claiming part of my land is actually HOA common area. That would be very unusual. The title search we conducted showed no claims or encumbrances on the property. You purchased it from the Hendricks family, correct? Yes, Tom and Martha Hendricks. And they'd owned it since 1994, well before the surrounding development was built. Your property is actually grandfathered in. It predates the HOA entirely. That last part hit me like a revelation. My property was here first. The neighborhood had been built around it later. Can you email me confirmation of all this? I asked. I'll send you everything we have on file. But Mr. Brennan, if someone is actually building on your land without permission, you need to contact an attorney immediately. I thanked her and hung up, then immediately started searching for property attorneys in Columbus. I found one with good reviews, Nathan Sullivan, whose website said he specialized in property disputes and boundary issues. His office was able to squeeze me in that afternoon at 2. Outside, I could hear the construction continuing. The sound of machinery, shouting workers, the beep of trucks backing up. They were really doing this. I got dressed properly, gathered all my documents, and spent the next few hours pacing my house and watching the construction through my windows. They were leveling ground, pouring concrete footings. This wasn't a temporary thing. They were building something permanent on my land. At 1:30, I drove to Nathan Sullivan's office in downtown Columbus. His suite was on the 4th floor of a modern building, all glass and steel. The receptionist led me to a conference room where Nathan was waiting. He was probably in his early 40s, with dark hair starting to gray at the temples and sharp, intelligent eyes behind wire-rimmed glasses. Mr. Brennan, he said, shaking my hand firmly. Tell me what's going on. I laid out the whole situation while he listened carefully, occasionally taking notes on a legal pad. When I finished, he pulled out my documents and examined them one by one. "This is pretty straightforward," he said after several minutes. "Your deed is clear. Your survey is clear. This field is unquestionably your property. The HOA has no legal right to build anything here. They claim they have plat maps showing its community common area." Nathan shook his head. "It doesn't matter what their maps show if those maps are wrong. Your property predates their development. They can't just claim it as theirs because it's convenient. Do you have any idea why they think they own it?" The HOA president, Patricia, seemed absolutely certain, like she couldn't even conceive that she might be wrong. That's common with HOAs, unfortunately. They're used to having authority within their communities, and sometimes that goes to people's heads. But her certainty doesn't change property law. He tapped my survey map. "This is a legally recorded document. It's in the county records. The title search confirmed your ownership. We have a very strong case here. So what do I do? First, I'm going to draft a cease and desist letter to be delivered today. It'll inform the HOA that they're trespassing on your property and must immediately halt all construction. Second, we're going to file for a temporary restraining order in court. That should be granted fairly quickly given how clear-cut this is. Third, if they don't comply, we'll pursue a permanent injunction and sue for damages. How long will all this take?" "The cease and desist can be delivered within a few hours. The restraining order we might be able to get by tomorrow afternoon if we're lucky, definitely by Wednesday. In the meantime, you should document everything. Take photos, videos, notes about what they're doing and when. Don't interfere with the construction yourself. Don't get into any physical confrontations. Let the law handle this." I left Nathan's office feeling slightly better. At least I had a plan. At least I was taking action. When I got home, the construction crew had made significant progress. The concrete footings were in place, and they were beginning to assemble the playground equipment itself. There was a large jungle gym, a slide, a swing set. It looked expensive and elaborate. I took my phone and walked around the perimeter of the construction site, filming everything. The workers watched me warily but didn't say anything. At 5:30, a courier arrived at my door with copies of the cease and desist letter. Nathan had worked fast. The letter was addressed to Patricia Donovan and the Meadowbrook Hills HOA board, clearly stating that the playground construction was on my private property and must cease immediately. "You're serving this to the HOA president?" I asked the courier. "Already delivered," she said. "Handed it to her personally about 20 minutes ago." "How'd she take it?" The courier, a young woman in her 20s, grinned. "Let's just say she wasn't happy. She kept saying it was harassment and that she'd have her attorney respond." Perfect. At least Patricia now knew I was serious. The construction crew packed up around 6 as the sun was setting. They'd return tomorrow morning, I assumed, unless the cease and desist actually worked. That night, I barely slept. I kept thinking about the playground going up on my field, about Patricia's absolute certainty, about how much this was going to cost in legal fees even though I was clearly in the right. Property disputes were expensive even when you won. The next morning at 7, the construction crew was back. The cease and desist had done nothing. I called Nathan immediately. "They're still building." "I expected that," he said calmly. "The cease and desist is really just documentation that we warned them. I'm in court this morning on your restraining order. Judge Ramirez is hearing it at 10. I'll call you as soon as I have news." "What are my chances?" "Very good. We have all the documentation we need. The HOA hasn't filed any adverse possession claim. They have no deed, no legal basis for their position. Judge Ramirez is fair. She'll see this for what it is." I spent the morning watching the construction and trying to work. I did data analysis from home, and normally I loved my job, but I couldn't concentrate at all. The sound of machinery and hammering kept pulling my attention back to the window. At 11:45, Nathan called. "We got it. Temporary restraining order granted. I'm having it served right now. All construction must cease immediately, and the HOA is prohibited from any further work on the playground pending a full hearing." Relief washed over me. "When's the hearing?" "Week after next. October 18th. Judge Ramirez wants to give both sides time to prepare arguments, though honestly, I don't see what arguments the HOA could possibly have. But we'll go through the process." "Thank you, Nathan. Seriously. Don't thank me yet. Let's see how the HOA responds to the restraining order." An hour later, a sheriff's deputy arrived at the construction site and spoke with Jim, the foreman. I watched from my deck as Jim made several phone calls, gesturing in obvious frustration. Then he gathered his crew, and they began packing up their equipment. The bulldozer was loaded onto a flatbed. The partially assembled playground equipment was covered with tarps. By 3 in the afternoon, the site was empty except for the concrete footings and the materials they'd leave behind. I thought that would be the end of it until the court hearing. I was wrong. That evening, my doorbell rang. I opened it to find Patricia Donovan standing there with 2 other people. A man in his 60s with gray hair and a stern expression, wearing a suit, and a younger woman, maybe early 30s, with dark hair pulled back, also in business attire carrying a briefcase. "Mr. Brennan," Patricia said, her voice dripping with barely controlled anger. "This is Richard Yates, our HOA vice president, and Jennifer Cole, our attorney." Jennifer stepped forward. "Mr. Brennan, I'm representing the Meadowbrook Hills Homeowners Association. We'd like to discuss this situation reasonably before it escalates further." "You built a playground on my land," I said. "It's already escalated." "We built a playground on what we believe in good faith to be HOA common area," Jennifer corrected. "There appears to be a genuine dispute about property boundaries. These things happen. What we'd like to propose is a compromise." "What kind of compromise?" Richard spoke up, his voice gruff. "We've already invested significant money in this playground. The community has been excited about it for months. Children are looking forward to it. What we're proposing is that you grant us an easement for the playground area. We'll pay you fair market value for that portion of land, and you keep the rest of your field. Everyone wins." I almost laughed. "You want me to sell you the land you already built on without asking?" "We're trying to resolve this amicably," Patricia said. "Going to court is expensive and time-consuming for everyone involved. You should have thought about that before you trespassed on my property." Jennifer pulled some papers from her briefcase. "We had our own surveyor take measurements today. According to his preliminary assessment, there's ambiguity in the property lines. The original surveys from the 1990s used markers that may have shifted or been removed. It's entirely possible that what you believe is your property actually falls within the community boundaries." "I have a legal survey from 2017, I said. "It's recorded with the county. There's no ambiguity." "Surveys can be wrong," Jennifer said, "or can be interpreted differently. Our surveyor has 40 years of experience. He's willing to testify that the boundary line is genuinely in dispute." I could see what they were doing. They were trying to muddy the waters, create doubt where none existed, make it seem like both sides had legitimate claims. "My attorney says my case is clear," I told them. "I think you should talk to him if you want to discuss this further." Patricia's composure cracked a little. "Do you have any idea how selfish you're being? This playground is for children, for our community. You have 12 acres. Would it kill you to share a small portion for a good cause? If you'd asked me before building, we could have discussed it," I said. But you didn't ask. You just took. That's not how property rights work." "This is ridiculous," Richard muttered. "We're the ones who have been reasonable here." "You're trespassing on my land and you think you're being reasonable." Jennifer held up a hand. "Mr. Brennan, please reconsider. The HOA is prepared to offer you $15,000 for a perpetual easement covering just the playground area. That's very generous considering the land is unused. You'd maintain ownership, we just have the right to keep the playground there." "No." "20,000, Patricia said quickly. "Final offer." "No amount of money makes this okay. You didn't ask. You didn't check. You just assumed. Now you're facing the consequences." We stood there in tense silence for a moment. Finally, Jennifer said, "We'll see you in court then." They left, and I closed the door, my hands shaking slightly. I didn't like confrontation, never had, but I wasn't going to let them bully me into giving up my property rights. The next week passed in a blur of preparations. Nathan deposed the HOA board members, gathered all the relevant surveys and documents, and prepared our case. I spent hours being interviewed, going over every detail of my property purchase and the timeline of the playground construction. The HOA, meanwhile, was apparently doing the same. Their attorney had hired an expert witness, a surveyor who was going to testify about supposed ambiguities in the property boundaries. Nathan assured me it was a desperate move that wouldn't work, but it still made me nervous. On the morning of October 18th, I drove to the Franklin County Courthouse, wearing the only suit I owned. Nathan met me outside. "Ready?" he asked, "as I'll ever be. Just remember, truth and documentation are on our side. Stay calm, answer questions directly, and don't let Jennifer get under your skin." The courtroom was smaller than I expected. Judge Ramirez sat at the bench, a woman in her 50s with sharp eyes and no-nonsense demeanor. Patricia, Richard, and another HOA board member I didn't recognize sat at one table with Jennifer. Nathan and I sat at the other. Judge Ramirez reviewed the case file, then looked up. "This is a hearing on Mr. Brennan's request for a permanent injunction preventing the Meadowbrook Hills HOA from constructing a playground on what he claims is his private property. Miss Cole, you're representing the HOA. Mr. Sullivan, you're representing Mr. Brennan. Let's begin." Nathan presented our case first. He walked the judge through my property purchase, the title search that showed no issues, the 2017 survey that clearly marked my boundaries, and the fact that my property predated the HOA development by many years. "Your Honor," Nathan said, "this is not a complex case. Mr. Brennan owns 12 acres of land. The survey is clear and legally recorded. The HOA built on his property without permission, without even notifying him. They only believe they have a right to this land because of outdated, incorrect maps from their original development. But belief doesn't override legal property ownership." Judge Ramirez examined the survey documents. "Miss Cole, what's your response?" Jennifer stood. "Your Honor, the HOA's position is that there is genuine ambiguity about the property boundaries. We've retained an expert surveyor, Donald Mitchell, who has examined the property and the historical records. He's prepared to testify that the original survey markers used in the 1994 property description may have been moved or destroyed, and that the 2017 survey may have been based on incorrect assumptions about where those markers should be placed. So you're claiming the 2017 survey is wrong?" "We're claiming it may be wrong, Your Honor. We're requesting that the court order an independent survey to definitively establish the boundaries before granting any permanent injunction." Nathan stood quickly. "Your Honor, this is a stalling tactic. The 2017 survey was conducted by a licensed, professional surveyor. It's legally recorded. The title company that insured Mr. Brennan's property accepted it. The HOA can't just claim it's wrong because it's inconvenient for them. Let's hear from this expert witness, Judge Ramirez said. Mr. Mitchell, an older man from the gallery, stood and came forward. He was sworn in and took the witness stand. He had thinning white hair and wore thick glasses, and he spoke with the slow, deliberate manner of someone used to explaining technical concepts. Jennifer questioned him about his qualifications. 43 years as a surveyor, licensed in Ohio and 3 other states, testified in dozens of cases. He was clearly experienced. Then she asked about his examination of my property. I visited the site last week, Donald said. I reviewed the 2017 survey conducted by Harris and Associates, and I examined the physical property to look for survey markers. The 2017 survey references iron pins that were supposedly placed during the 1994 survey when Mr. Brennan's predecessors owned the property. However, I could not locate several of these pins. Without those original markers, the 2017 survey may have had to estimate their positions. And what would that mean for the accuracy of the boundary determination? Jennifer asked. It would introduce uncertainty. Survey markers can be removed, either deliberately or accidentally during construction or landscaping. If the 2017 surveyor couldn't find the original markers and had to estimate based on the legal description, there could be errors of several feet or even tens of feet. So the playground might actually be on HOA property. Objection, Nathan said. Speculation. Sustained, Judge Ramirez said. Miss Cole, please rephrase. Is it possible that the true boundary line is different from what the 2017 survey shows? It's possible, yes, Donald said. Nathan cross-examined him. Mr. Mitchell, did you conduct a full survey yourself? No, not yet. That would require more time and the property owner's permission. So you're testifying about possibilities, not certainties. I'm testifying about legitimate concerns regarding the accuracy of the 2017 survey. Are you aware that Harris and Associates is one of the most respected surveying firms in Central Ohio? Yes, I know them. And are you suggesting they were negligent or incompetent in conducting the 2017 survey? Donald hesitated. Not necessarily, but all surveys have limitations. Without the original markers, there's room for error. The legal description of Mr. Brennan's property uses meets and bounds, not just markers, distances and angles from established points. Even without every single marker, a competent surveyor can accurately determine boundaries. Correct, generally, yes, but... And you haven't found any mathematical errors in the 2017 survey, have you? I haven't conducted that level of analysis. So your testimony boils down to the fact that you can't find some old markers, and therefore you're raising doubts. But you have no evidence the 2017 survey is actually wrong. I have concerns about its accuracy. Concerns, not evidence. Thank you, Mr. Mitchell. Judge Ramirez called for a recess. Nathan and I stood in the hallway. How do you think it's going? I asked. Good. Mitchell's testimony is weak. He's basically saying maybe there's a problem without any real proof, but judges sometimes err on the side of caution. She might order a new survey just to be absolutely certain. When we returned, Judge Ramirez questioned me directly about when I became aware of the construction and what steps I'd taken. I explained everything, trying to sound calm and reasonable. Then she questioned Patricia. Miss Donovan, when the HOA decided to build this playground, what due diligence did you do regarding the land ownership? Patricia sat up straight. We reviewed our original development plat maps from 2001. The field in question was clearly marked as common area reserved for future community use. We had no reason to believe anyone else owned it. Did you check with the county recorder's office? Did you look at current property surveys? No, Your Honor. We relied on our own documents. We've been managing this community for 24 years. We know what property belongs to the HOA. Apparently not, Judge Ramirez said dryly. Did you at any point contact Mr. Brennan to discuss the playground? We sent out a newsletter to all residents about the playground project. Is Mr. Brennan a resident of your HOA community? Patricia paused. No, Your Honor. His property isn't technically part of Meadowbrook Hills, but it's directly adjacent, and we thought he might be interested. But you didn't specifically notify him that you plan to build on what he believes is his land. We didn't realize it was his land, Your Honor. Our maps showed otherwise. Maps from 2001, which might not reflect the actual property boundaries. Patricia's face was reddening. We acted in good faith. We spent over $40,000 on this project. The community has been looking forward to it for months. We're not trying to steal anyone's land. We genuinely believed it was ours. Judge Ramirez made some notes, then looked up. Here's my ruling. The 2017 survey appears professionally done and properly recorded. However, given Mr. Mitchell's testimony about missing markers, I want absolute certainty before making a final determination. I'm ordering an independent survey to be conducted by a court-appointed surveyor at the HOA's expense. This survey will definitively establish the property boundaries. The temporary restraining order remains in effect until this survey is complete and I can make a final ruling. We'll reconvene in 30 days. I felt deflated. 30 more days of uncertainty. Nathan put a hand on my shoulder. It's not ideal, but it's not bad either, he whispered. She's being thorough. The survey will confirm what we already know, and then you'll have an ironclad case. Outside the courthouse, Patricia confronted me. I hope you're happy. You're depriving children of a playground because of your greed. I'm protecting my property rights, I said. That's not greed. You have 12 acres. We're asking for a tiny fraction of it. Then buy your own land, Patricia. Don't steal mine. She stormed off, and Richard glared at me before following her. The next month was frustrating. The court-appointed surveyor, a woman named Sandra Leung, contacted me to schedule a time to survey the property. She spent 3 days doing detailed measurements, using modern GPS equipment combined with traditional surveying tools. She was professional and thorough, explaining each step of her process. I'm looking for the original survey markers, she told me, and also using the legal description to calculate where the boundaries should be based on the established reference points. I'll also compare my findings to the 2017 survey to see if there are any discrepancies. What do you think so far? I asked. I don't make judgments until I've completed my work, she said with a slight smile. But I can tell you that the 2017 survey appears well documented. Harris and Associates keeps good records. While waiting for Sandra's report, life went on. I tried to focus on my work, tried not to obsess over the situation, but it was always there in the back of my mind. The playground equipment sitting under tarps on my field, the concrete footings, the empty construction site. Neighbors from the Meadowbrook Hills development would occasionally walk by on the road, and some would give me dirty looks. Word had apparently spread that I was the bad guy preventing their playground. One woman actually shouted at me from the street one evening, calling me selfish. I just went back inside. In mid-November, Sandra completed her survey. Her report was filed with the court, and Nathan got me a copy immediately. "Read the conclusion," he said over the phone, and I could hear the satisfaction in his voice. I flipped to the final page of the technical report. Based on extensive field measurements and analysis of all available documentation, I have determined that the 2017 survey conducted by Harris and Associates accurately reflects the property boundaries of the Brennan property. The field where the HOA began playground construction is entirely within the Brennan property bounds. The eastern boundary line is approximately 73 feet east of the playground site. There is no ambiguity or uncertainty regarding these boundaries. I felt a weight lift off my shoulders. Finally, definitive proof. The hearing was scheduled for November 22nd, the day before Thanksgiving. Judge Ramirez reviewed Sandra's report, then looked at both attorneys. Miss Cole, the independent survey confirms Mr. Brennan's position. The HOA built on his land. Do you have any further arguments? Jennifer looked defeated. No, Your Honor. We accept the survey's findings. We respectfully request that the HOA be given reasonable time to remove the playground equipment and restore the property. Mr. Sullivan, Nathan stood. Your Honor, we're requesting a permanent injunction prohibiting any future trespass, removal of all equipment and materials at the HOA's expense, restoration of the property to its original condition, and compensation for Mr. Brennan's legal fees and damages. Judge Ramirez nodded. Granted. Permanent injunction issued. The HOA has 30 days to remove all equipment and materials and restore the land. Mr. Brennan is awarded legal fees and costs, to be calculated and submitted within 2 weeks. Furthermore, the HOA is liable for any damage to the property and must compensate Mr. Brennan accordingly. She banged her gavel. This case is closed. Patricia looked like she'd been slapped. Richard was shaking his head in disbelief. Jennifer was packing up her briefcase with quick, angry movements. Outside, Nathan shook my hand. Congratulations. You won definitively. How much do you think the legal fees will come to? Probably around $25,000, plus whatever damages we can document. The ground disruption, the trespass, the stress and inconvenience. Maybe another $10,000, $35,000, more than the HOA had spent on the playground itself. They'd be furious. I drove home feeling vindicated but also exhausted. The whole ordeal had taken over a month and had been incredibly stressful. I was glad it was over, but it wasn't over. 2 weeks after the hearing, I got a call from a lawyer I didn't know. Mr. Brennan, my name is Marcus Webb. I represent Great Lakes Liability Insurance, the company that provides liability coverage for the Meadowbrook Hills HOA. I need to speak with you about a rather unusual situation. What situation? I've been reviewing the recent court case regarding the playground. As part of our standard procedures, we've examined the situation and we have some serious concerns. May I meet with you? This could actually be beneficial for your position. Intrigued, I agreed to meet him that afternoon at a coffee shop in Powell, a town just north of Columbus. Marcus was a tall, thin man in his early 50s with receding hair and a crisp suit. He ordered a black coffee and got right to the point. Mr. Brennan, insurance companies pay close attention to liability issues. When the HOA built that playground, they notified us, and we agreed to cover it under their general liability policy. Playgrounds are high-risk amenities, lots of potential for injuries and lawsuits. Okay, I said, not sure where this was going. But our coverage is predicated on the playground being on HOA property. Now we've learned, through the court case, that the playground was actually built on your private land. That changes everything. Understanding dawned. Because if someone got hurt on the playground, the liability would fall on me as the property owner. Exactly. And the HOA never informed us that there was any question about the land ownership. They represented it as being built on their property. That's a material misrepresentation. We're within our rights to deny coverage and potentially cancel their policy altogether. Have you told them this? Marcus smiled grimly. I informed Patricia Donovan yesterday. She's claiming they didn't knowingly misrepresent anything, that they truly believed it was their land. But intent doesn't really matter here. The fact is, they built a playground on someone else's property and expected us to insure it. That's not how liability insurance works. So, what happens now? We've dropped their coverage for the playground specifically. If it's not removed from your property and someone gets injured, any lawsuit would fall entirely on them, with no insurance protection. We're also reviewing their entire policy. Building on land you don't own suggests poor management and judgment. We may not want to continue insuring them at all. Wow, I said. I didn't even think about the insurance angle. Most people don't, but it's a huge issue. The HOA is now facing massive liability exposure. If they don't remove that playground immediately and if some kid climbs on it and gets hurt, they could be sued for everything. Medical bills, pain and suffering, negligence, trespass. Without insurance, that could bankrupt the HOA. Good, I said, surprised by my own vindictiveness. But after everything they'd put me through, I didn't feel much sympathy. Marcus leaned forward. Here's why I wanted to talk to you. You should send a formal notice to the HOA that you're aware of the insurance situation, and that you consider any continued presence of the playground to be a dangerous condition creating liability. Document everything. If they don't remove it quickly and someone does get hurt, you want a clear record that you warned them and they ignored you. Will do. Thank you for letting me know. It's in our interest, Marcus said. If the HOA tries to claim insurance coverage after an injury, we need to show that they were on notice about the problem and chose not to fix it. Your documentation helps us. I left the coffee shop and immediately called Nathan. He was delighted with this new development. This is perfect, he said. The insurance company dropping them adds massive pressure. I'll draft a notice letter today. We'll make it clear that the playground is a hazardous condition on your property and that the HOA must remove it immediately or face additional legal action. The letter was sent the next day. I also took photos of the playground equipment still sitting under tarps, the concrete footings, all of it. The 30-day deadline Judge Ramirez had set was approaching, and nothing had been removed yet. On December 1st, I drove over to the Meadowbrook Hills HOA office, a small building near the neighborhood entrance. I wanted to see if they were actually going to comply with the court order. The office was open, and I walked in. A young woman sat at the front desk. Is Patricia Donovan available? I asked, may I ask what this is regarding, the playground situation? The receptionist's expression soured. Please wait here. A few minutes later, Patricia emerged from a back office. She looked tired and angry. Mr. Brennan, come to gloat. I came to see if you're planning to remove the playground equipment. We're working on it, she snapped. Do you have any idea how expensive it is to disassemble and remove everything? Not to mention we now have to pay your legal fees. You should have thought about that before you built on my land. Patricia's eyes flashed. You know what? This whole neighborhood thinks you're a horrible person. You could have been neighborly. You could have worked with us. Instead, you're costing us tens of thousands of dollars and depriving children of a playground. I'm not depriving anyone of anything. You can build a playground anywhere you want as long as it's on land you own. We don't have another suitable location. That field was perfect. It's flat. It's central to the neighborhood. It's near the walking paths. Now we have to find somewhere else, purchase more land probably, and the costs are going to be enormous. That's your problem, not mine. Patricia's voice rose. People like you are what's wrong with America. No sense of community. No willingness to compromise. Just mine, mine, mine. You have 12 acres. Would it have killed you to share a tiny piece? Would it have killed you to ask first? I shot back. Would it have been so hard to knock on my door and say, hey, we'd like to build a playground? Can we talk about using part of your field? We could have negotiated. I might have said yes. But you didn't ask. You just took. Because we didn't think we needed to ask. It was supposed to be our land. But it wasn't. And now you're facing the consequences. I suggest you start removing that equipment before the deadline expires. Because if you don't, I'll be back in court asking for contempt charges. I left before she could respond. I was done being polite with these people. Over the next week, contractors finally showed up and began dismantling the playground. I watched from my deck as they unbolted the swing set, disassembled the jungle gym, carefully removed the slide. Everything was loaded onto trucks and hauled away. They jackhammered out the concrete footings, leaving holes in the ground. Then they brought in loads of topsoil and filled everything in, roughly grading it to match the surrounding field. It wasn't a perfect restoration, but it was close enough. By December 10th, the field was empty again. My field. The way it should have been all along. Nathan filed our claim for legal fees and damages. The total came to $38,000. The HOA had to pay it, though I heard through the neighborhood grapevine that it had nearly depleted their reserve fund. They'd had to assess each homeowner an additional $500 special assessment to cover the costs. I felt a little bad about that. The individual homeowners hadn't done anything wrong, but they'd elected Patricia and the board. They were responsible for their HOA's actions. In late December, I got another surprise call. This time from someone named Susan Martinez with the Ohio Department of Commerce. Mr. Brennan, I'm calling regarding a complaint we received about your property. Specifically, a complaint that you're illegally preventing community access to public recreational space. I'm sorry, what? We received a formal complaint from Patricia Donovan, president of the Meadowbrook Hills HOA. She claims that a field on your property was designated as public recreational space in the original development plans and that you're illegally restricting access. I couldn't believe it. Patricia was still fighting this. Miss Martinez, this was litigated in court. A judge ruled that the field is entirely my private property. The HOA was ordered to remove a playground they'd built without permission. Oh, Susan said, her tone shifting. The complaint didn't mention any court case. You have documentation. I have the entire court file. I'll email it to you. Please do. If there's been a legal determination of ownership that resolves our inquiry, I'm sorry for the confusion. I sent her everything. 2 days later, she emailed back confirming the complaint was closed and that the department had sent a letter to Patricia warning against filing false complaints. But Patricia wasn't done yet. In January, I received notice that the HOA was filing an appeal of Judge Ramirez's decision. Jennifer Cole was arguing that the judge had erred in not ordering additional surveys or entertaining alternative interpretations of the property descriptions. Nathan assured me the appeal was frivolous and would likely be dismissed, but it still meant more legal proceedings. The appeal would be heard by a 3-judge panel, probably not until spring. They're just being vindictive at this point, Nathan said. They know they lost. They're just making you jump through hoops because they're angry. The appeal hearing was scheduled for March 14, 2025. Nathan filed a comprehensive brief laying out all the facts, the surveys, the title history, everything. The HOA's brief was surprisingly thin, mostly arguing procedural points and claiming the judge had been biased. I didn't have to attend the hearing. Nathan went alone and called me afterward. Dismissed, he said. The panel didn't even take a full hour. They said the evidence was overwhelming, the trial court's ruling was correct, and the appeal was without merit. It's over, for real this time. I felt relief wash over me. Finally, truly over, but there was one more twist coming. In April, I saw on the local news that the Meadowbrook Hills HOA was being sued by several of its own residents. Apparently, the financial cost of the playground fiasco had been devastating. The special assessment to cover legal fees had angered homeowners, and some had started digging into the HOA's finances. They discovered that Patricia and Richard had authorized the playground construction without proper board approval. The HOA bylaws required a full board vote for any expenditure over $10,000. Patricia and Richard had essentially acted unilaterally. The lawsuit alleged breach of fiduciary duty, mismanagement, and financial misconduct. It was an internal civil war within the HOA. I watched it from a distance, feeling no satisfaction. I hadn't wanted to destroy the HOA. I just wanted my property rights respected. In May, Patricia resigned as HOA president. Richard resigned as vice president. Jennifer Cole withdrew as their attorney. The HOA held emergency elections and installed a new board. The new president, a woman named Diane Fletcher, called me one afternoon. "Mr. Brennan, I wanted to introduce myself. I'm the new HOA president. I want to apologize on behalf of Meadowbrook Hills for everything that happened. The previous board acted inappropriately and illegally. That's not who we are as a community." "I appreciate that," I said, surprised. "I also wanted to let you know that we've found an alternative location for a playground. We purchased a small parcel near the neighborhood pool. It's not as ideal as the field location, but it's on property we actually own. We've learned our lesson." "That's good to hear. And Mr. Brennan, if you ever want to be involved in community events or anything like that, you're always welcome. I know you're not technically part of our HOA, but you're our neighbor." It was a nice gesture. "Thank you, Deanne." After hanging up, I walked out to my back deck and looked at the field. It was early evening, the sun setting orange and pink on the horizon. The grass had grown back over the areas where the construction had been. In a few months, you'd never know anything had happened there. I thought about everything that had occurred. The shock of seeing construction on my land. The confrontations with Patricia. The legal battles. The stress and expense. All because the HOA hadn't done basic due diligence. But I'd stood my ground. I protected my property rights. And in the end, the law had worked exactly as it should. Clear property ownership, proper documentation, and a fair judge had led to the right outcome. I didn't regret fighting the HOA. Property rights matter. You can't just take something because you want it, because it seems convenient, because you think your cause is righteous. There are rules. There are procedures. There's respect for ownership. The whole situation had taught me something about HOAs, though. They could be useful for managing shared spaces and amenities, but they could also become little fiefdoms where board members wielded power without accountability. Patricia had been so used to authority within her community that she couldn't imagine being wrong. She'd assumed the field was hers because her map said so, never bothering to check legally recorded documents or ask questions. That arrogance had cost the HOA dearly. Tens of thousands in construction costs, legal fees, restoration, and now internal lawsuits. All because Patricia couldn't admit she might be wrong until a judge forced her to. In late June, I was mowing my lawn when a car pulled up. A man in his 30s got out, looking around at the property. "Can I help you?" I called. "Are you Xavier Brennan?" "Yeah. I'm David Chen. I'm a reporter with the Columbus Dispatch. I've been covering HOA disputes in Central Ohio, and I heard about your case. Would you be willing to talk about what happened?" I hesitated. Part of me wanted to just move on and forget the whole thing, but another part thought maybe sharing the story could help other people. "Sure," I said. "Come on in." We sat at my kitchen table and I told David everything. The construction crew showing up unannounced, Patricia's absolute certainty, the legal battles, the insurance company dropping coverage, the appeals, all of it. David took notes furiously. "This is a perfect example of HOA overreach. Did you know there have been 4 similar cases in Franklin County in the past 3 years? HOAs acting beyond their authority, trespassing on private property, assuming rights they don't have." I didn't know that. It's a growing problem. As neighborhoods develop and HOAs become more common, some boards get drunk on power. They forget that they're just community organizations, not government entities. They have no power beyond what their members grant them and what the law allows. "That's exactly what happened here," I said. "Patricia acted like she was some kind of authority figure, like her word was law. And she faced no personal consequences," David noted. "She resigned, but she wasn't sued personally, wasn't charged with anything. The HOA as an entity paid the price, which really means the homeowners paid. Is there a way to hold board members personally accountable? It's difficult. HOAs are usually structured as corporations, which provides personal liability protection for board members unless they commit fraud or gross negligence. What Patricia did was arguably gross negligence, but proving that legally is hard." The article David wrote appeared a week later. It was a long piece about HOA governance problems, using my case as a central example. The headline read, "When HOAs Overstep, Property Rights Battles in Suburban Ohio." The article generated a lot of discussion. I got emails from people sharing their own HOA horror stories. Some were worse than mine. HOAs that had foreclosed on homes over minor violations. HOAs that had banned holiday decorations or certain colors of paint. HOAs that had assessed thousands in fines for lawn care issues. It made me grateful that my property wasn't actually part of an HOA. I'd bought it specifically for the freedom to do what I wanted with my land. The irony was that the HOA had nearly taken that freedom away. As summer turned to fall, life returned to normal. The field was completely recovered. I'd started planning that workshop I'd always wanted, getting quotes from contractors. Maybe I'd even get those horses eventually. One afternoon in September, I saw kids playing in the new Meadowbrook Hills playground. It was near the pool, visible from the road. The kids were laughing and running around, and I felt glad for them. They deserved a place to play. I'd never been against the idea of a playground. I'd just been against having one forced onto my property without permission. If Patricia had approached me from the start with respect and humility, things might have turned out differently. I might have negotiated an easement or even donated a portion of the field. But the moment she assumed she had the right to my land, the moment she dismissed my concerns and kept building despite my objections, any possibility of compromise had died. That was the real lesson. Respect people's property. Ask permission. Follow the law. It wasn't complicated. I never saw Patricia again. I heard she'd moved out of the neighborhood, the stress and shame of the situation having become too much. Richard was still around but kept a low profile. The new HOA board seemed competent and careful. They'd implemented new procedures requiring legal review of any significant projects. They'd brought in an outside management company to handle finances. They were trying to rebuild trust. In October, almost exactly a year after the construction crew had first appeared on my field, I was sitting on my deck with a beer watching the sunset. My phone rang. It was Nathan. "Just wanted to check in," he said. "How's everything going?" "Good, quiet. Finally." No more HOA drama. None. I think they learned their lesson. You'd be surprised, Nathan said. I'm currently representing 3 other clients in property disputes with HOAs. It's more common than you'd think. That's depressing. It is, but your case had a good outcome. Clear victory, property restored, fees recovered. Not all of them go that well. After we hung up, I thought about how lucky I'd been in a strange way. Lucky that I'd had clear documentation. Lucky that I could afford an attorney. Lucky that the surveyor confirmed my position. Lucky that the judge was fair. Not everyone in a property dispute would have all those advantages. Some people might have been pressured into giving up their rights, unable to afford the legal fight, or worn down by the process. I'd been able to stand firm because I had the resources and the evidence, but it shouldn't have been necessary. The HOA should have done their homework before building. They should have checked property records. They should have asked questions. Instead, they'd assumed, acted arrogantly, and paid the price. As darkness fell over the field, I raised my beer in a silent toast to property rights, to justice, to standing your ground when you're right. The field was mine. It had always been mine, and now everyone knew it.